Tyne Hospital's NHS Trust Foundation against Abbasi and Anor, and King's College NHS Foundation Trust against Haastrup and Anor. Yes, Mr. Miller.
Lords, in these two appeals I appear with Fiona Patterson KC for the Appellant NHS Trusts. My learned friend Mr. Quintavale appears for the parents in each case. There are also written interventions on behalf of the British Medical Association, the Royal College of Nursing, the Faculty of Intensive Care Medicine, and a joint intervention from the Royal College of Paediatrics and Child Health and the Paediatric Critical Care Society. Those four in support of the appellants. And finally, an intervention on behalf of the Free Speech Union in support of the parents on the merits. The appeals concern injunctions against the World, referred to for convenience as reporting restriction orders, made in end-of-life cases in the family division. Tragically, the Abbasi's 6-year-old daughter Zainab died before the proceedings brought by Newcastle came to a hearing. And ventilation was withdrawn from Mr. Haastrup's baby son, Isaiah, following a full hearing and a best interest declaration obtained by King's. It's right and important that the children should be remembered at the outset. The injunctions are in the Court of Appeal's judgment at paragraphs 16 and 22, and the court will have read those. They were, in the Abbasi case, an injunction in 2019, September, and in the Haastrup case in October 2017.
Do you have the electronic page numbers for those?
Yes. EF 283 is the Abbasi injunction, and 286 is the Haastrup injunction.
Thank you.
They prohibited publication, that's the key word, of information identifying clinicians who had cared for the children, being in the Abbasi case a group of 4 clinicians identified in a record attached to the injunction, and in the Haastrup case a much larger group. The appeal arises because the injunctions continued following the deaths of the children, and they continued to 2020 when the parents, wanting publicly to identify treating clinicians in conjunction with criticisms of them, made applications to Sir Andrew McFarlane, the president of the family division, to discharge them. By his decision of the 23rd of June 2021, he continued them, but his decision was overturned by the Court of Appeal last year. While each court held that there was jurisdiction to make and continue the injunctions, they reached very different decisions as to whether the privacy rights of the clinicians or the free speech rights of the parents should prevail. We say on this appeal that the President's reasoning and decision were not wrong, and that the Court of Appeal was not entitled to interfere with that decision, and that the injunction should continue. As the court will have seen from the papers, as below, there is a cross appeal in which the parents contend that the family division of the High Court had no power to make the injunctions, alternatively to continue them. Therefore, subject obviously to the views of the court, we would propose first to advance our case on the jurisdiction issue, before secondly addressing the reasoning of the President, which we seek to uphold, and then thirdly look at our challenge to the grounds on which the Court of Appeal allowed the parents' appeal. Dealing first, therefore, with jurisdiction, we seek to uphold the reasoning of the Court of Appeal on that issue, which is at 45 to 68 in the Court of Appeal's judgment, pages 293 to 298. And that was based on the Ries, INRI, BBC, and Guardian News and Media cases. And I was proposing to look at those cases first. They're quite familiar, so please do stop me if you don't think it's helpful. but they're also relevant beyond jurisdiction to some of the other issues that we're going to look at. So hopefully that makes sense, and I'll pick up some of the other points in those cases that are relevant to the other issues as we go through them on jurisdiction.
A point that you might want to cover is that these authorities are concerned with the reporting of matters which have been disclosed in court. And the orders we're concerned with here are not confined in that way. And in principle, if the order can extend to matters that have not been disclosed in court, then really it seems to us you could have a freestanding application for an injunction, even if the hospital was not required to come to court for an end-of-life order. So the implications are somewhat wider.
Yes, yes. But on the Lord's point, in Read BBC, the information had not come out in open court. On the Attorney General's reference, the defendant was anonymised in those proceedings. His name had come out in the underlying criminal proceedings in the Crown Court. I'll come to
you understand.
It's a mixture.
This is a point that we're alive to.
Absolutely, and it's not we make the point in our case that it's not a straightforward issue of information that comes out in open court being prohibited, publication thereof. It stretches further than that. But we need to see the principal basis on which we say you can get to that point, which comes from these three cases. So Ries was a very well-known case, family division case involving an 8-year-old boy. It's at page 3149, Authorities Volume 2, tab 43. Care proceedings by the local authority had resulted in findings of fact that his older brother had been poisoned by their mother, and she was charged with his murder to stand trial at the Central Criminal Court. S was not concerned in the proceedings within the meaning of Section 39 of the Children and Young Persons Act 1939, because S was neither a party to nor a witness in the criminal proceedings. Therefore, the Crown Court, the Central Criminal Court, had no power to order the media not to identify him through its reporting of the criminal trial. The child's guardian therefore obtained an order from the family division in the care proceedings, preventing his identification in the reporting of the family proceedings. But the order contained a familiar proviso that one sees in family division orders, allowing his identification through reporting of other open court proceedings, to wit, the criminal proceedings at the Central Criminal Court. An appeal to the Court of Appeal failed, and Lord Tyne gave the leading judgment in the Appellate Committee, with which the other members of the committee agreed. Before the Appellate Committee, it was recognised that the issue, which was essentially should that proviso, open court reporting proviso, be removed, turned on the interaction between Articles 8 and Article 10 of the Convention. That's paragraph 16 in the judgment at 3153. So this is really the start of this line of authorities at this appellate level. That interaction, as the court will probably be aware, had been considered by the Appellate Committee in the Naomi Campbell case a few months before, and Lord Tyne took his 4 well-known propositions at paragraph 17 on 3153 regarding the balancing process from the opinions of the law lords in Campbell. The court will be very familiar with that methodology and the 4 stages that the judges are required to go through in balancing Article 8 and Article 10.
Looking at the third of the points that Lord Tyne makes, the justifications for interfering with or restricting each right being taken into account, is that, in your submission, when you're balancing the 2 rights, You're not adding weight to Article 8 because there is a restriction on Article 10 in terms of the wording of the article, but you're reducing the weight of Article 10 if there are public policy interests which qualify the freedom of expression.
Yes, that would be our case. They're distinct stages, and one has to give meaning to the last two stages, to justification and proportionality. They have to mean something. The content of those stages has to comprise something other than a straightforward balancing of the two rights in play. And the question that the court's going to have to grapple with is what comes into the consideration of the judge at those stages if it's done the balancing of the Article 8 and the Article 10 rights.
Yes. So the third point is referring to the restrictions within the convention itself on the particular right that is going into the balance.
Yes. So you say, if I was to go this way and restrict the Article 10 right, what would the justification for that be? And would the restriction that I'm considering be proportionate? You go the other way and say, I'm going to restrict the Article 8 right. Well, what would the justification for that be? And would it be a proportionate measure restricting the Article 8 right? So the judge has to look at the two possible outcomes in the light of all the evidence in the case and decide which one wins out, which one prevails.
In paragraph 16, after setting out Article 10, Lord Steyn refers to section 12.4 of the Human Rights Act. Do you have any submission as to the effect of that provision?
It's been rather neutralised by decisions of the Strasbourg court and more particularly the courts in this country. I'll come to the PJS case in due course, but subsequent decisions in Strasbourg after the von Hanover case made clear that both of the rights started, as Lord Steyn says in his first proposition, from presumptive parity. So there's nothing inherent in either right which gives it priority over the other in the balancing exercise. And the problem with 12.4 has always been that it seemed to shift the balance in favour of Article 10, and it's never really. Maybe this is not for us to say. It's on the authorities. It's never really bitten in the way that perhaps Parliament intended it, in light of the changes in the convention law. There used to be a piece of law in a case where Lord Hoffman talked about a trump the press's right to freedom of expression being a trump card. Section 12.4 wasn't quite like that, but it was supposed to shift the balance in favour of freedom of expression over privacy, but once it's clear that the two rights start from presumptive parity, it's very difficult to work that thinking into the balancing exercise. That's really the problem. The critical feature of the case was, as you'll see from paragraph 18, was the strong rule that, or presumption, that in domestic and convention law, everything emerging in a criminal trial in open court, such as the mother's murder trial, could be reported. And of course, if the press had to avoid identifying S in its reporting of the murder trial, it would have had to completely anonymise the mother as the defendant in order to prevent jigsaw identification of S by virtue of his relationship with her. So what was being proposed in the child's application would have been a very drastic derogation from open justice in the criminal proceedings. Paragraph 20 on 3154, importantly, Lord Steyn noted that there were mandatory and discretionary statutory exceptions to the open justice principle, and that the courts could not, and I quote, by a process of analogy, except in the most compelling circumstances, create further exceptions to open justice. That proposition and that paragraph become relevant when we come to some other aspects of the Court of Appeal's reasoning other than jurisdiction. The question arises, what exactly was he saying there? What did he mean? And what was he intending to restrict? One of those provisions, statutory provisions, was Section 39, which I've mentioned, of the Children and Young Persons Act 1933, which the order sought would, in effect, you can see, have been extending by requiring anonymisation of S when the Central Criminal Court itself could not order this because S was not a child concerned in the proceedings. And at the end of 21, Lord Steyne pointed out that that was, the wording is quite important, that was a factor that couldn't be ignored, weighing against granting the injunction, namely that there had been a legislative choice not to extend the right to restrain publicity in favour of a child at a criminal trial in that way. On jurisdiction, at paragraph 22, importantly, again, it was recognised throughout the injunction proceedings in Ries that the Family Division of the High Court was exercising the inherent jurisdiction it had to protect minors. In Latin, the parens patriae jurisdiction, including by making injunctions to protect a child who was or was becoming the object of publicity. And including by making injunctions to prevent identification of the child through publicity. And there had been many cases of that decided in the Family Division going back over the years in that parens patriae jurisdiction, which were referred to in the Appellate Committee in the argument. But when the case came before the Appellate Committee, it took the opportunity to emphasise that in this or similar cases, the High Court should not concern itself with all that case law about the existence and scope of this traditional common law inherent jurisdiction to make injunctions against the world, the applicability of which it was said was not in doubt in S's case. And at 23, you can see Lord Steyne's saying that and saying in the fourth line that the foundation of the jurisdiction to restrain publicity in a case as the present is now derived from convention rights under the ECHR. On the evidence, the Article 8 right of S was found to be engaged by the prospect of jigsaw identification that the family were concerned about, that the guardian was concerned about. But the injunction was refused essentially because, as you can see from 25 and 26, 3156.
Sorry, just on 23, and Lord Steyne doesn't seem to be distinguishing between different senses of the word jurisdiction. So, I mean, there's quite a lot of case law that distinguishes between jurisdiction in the sense of amplitude of the power available and jurisdiction in the sense of the relevant principles that govern the exercise of that power.
Yes.
What do you say Lord Steyne is talking about where he says the foundation of the jurisdiction to restrain publicity in a case like the present is now derived from conventional rights under the
way we would
ECHR?
put it, as the Court of Appeal did, is the vehicle for the issue being decided by the court is the inherent jurisdiction and the proceedings under the inherent jurisdiction. The legal basis on which you decide how to exercise that power to restrain publicity in favour of the child is no longer a string of common law cases, but is the balancing exercise under Article 8 and Article 9.
Right, so are you saying that Lord Tyne is saying that there is, if you like, the full amplitude of the power of the High Court jurisdiction in that sense to make any order it likes, if you like, but that when one comes to the principles governing the exercise of that wide power, it's governed by, I suppose, Section 6 of the Human Rights Act as it applies in relation to a court?
Exactly. And that's what comes to pass in the two later cases.
Yes, correct, thank you.
I assumed at some stage we're going to be taken to our recent judgment in the Wolverhampton case.
Yes.
Because we did analyse this question there, and we took the view, I think, but shortly, that's just been expressed, that the basis of the jurisdiction and the sense of the source of the power is equity, the inherent jurisdiction of the court. But Section 6 then guides how you exercise the jurisdiction in a case where convention rights are relevant.
Precisely. But the circumstance here was family division proceedings under the inherent jurisdiction. That was the vehicle, if you like, in which the issues were arising. Lord Steyn, 25 and 26, refused, the injunction was refused essentially because the impact on the child would be indirect. And in fact, the media had made clear they would not name the child, even if his name came out in open court at the Old Bailey. And 26, there was no relevant statutory exception to open justice for this situation, no precedent for such an order here or in Strasbourg. And then at 30, as I've said, on the other side of the balance was the strong right of the media to report criminal trials without restriction. Perhaps importantly, when we come to look at what we've called the generic evidence self-direction in the Court of Appeal, the House of Lords here had regard to very wide consequences for the press, especially the local press, of injunctions of this sort being available in relation to criminal trials. And you'll see that at 34 to 36, where Lord Steyn took into account that reporting of criminal trials and the public interest in the same would suffer if an injunction like this were granted for a variety of reasons. At 34, he thought that this and future anonymised criminal trials would be given less prominence by editors. 35, newspapers may not be able to afford to or be in time to contest injunctions. 36, most interestingly perhaps, having looked at website statistics about the readership of local as opposed to national newspapers, that local papers would be the most vulnerable to the development of the jurisdiction that was being considered. So some of these points we will return to later, but it seems to us that regarding the jurisdiction issue, the most important point is recognition of the width of the jurisdiction in principle in the vehicle of the inherent jurisdiction. The assumption was that it was wide enough to make possible, in principle, the order sought. But the decision was rather not to make the order on the facts of this case. So that's quite a striking point about Ries. The court left open the possibility that there might be a Ries-type case, but put forward arguments why, on the facts, it would be an exceptional case. So 4 months before Ries, the Strasbourg court had given judgment in the very well-known case of von Hanover versus Germany, number 1, which was an application under Article 8 after the German courts had failed to prevent publication by the media of photos of Princess Caroline of Monaco and her family in public places, but not on official duties. The European Court found a violation of her Article 8 rights. The judgment is at 4275, which is Authorities Volume 3, tab 83, 4274. And I'm going straight to the first part of paragraph 57.
I think I misheard your page number.
4274.
Thank you.
Mr. Miller, before going there, what do you say is the position if there aren't end-of-life proceedings and there is an anticipation that there is a need for some relief? What proceedings do you envisage could be taken? The hospital has not commenced end-of-life proceedings under the inherent jurisdiction.
Yes.
What then?
Well, you would need litigant, you'd need a claimant. Yes. There has been an issue in these proceedings, hotly disputed, whether the litigant could be the hospital on behalf of the clinicians. We say it could be. We say that there are various candidates, but we say the likeliest candidates for what would be thus far a novel claim. We don't have a case of this sort. would be a claim for invasion of privacy of those clinicians, of the identified clinicians, of the sort discussed in the PJS case, in particular by Lord Mance, where this court widened the misuse of private information talk beyond confidential or secret or sensitive personal information to look at, and we'll come to look at this later, the impact of not having an injunction, in that case lifting an injunction, the impact of not having an injunction in the social media age, to prevent publication of the names of people who would suffer intrusion and distress if there was no injunctive protection, if all that could happen. And that was a development in the law of tort, of that particular tort, that was of considerable importance. But in most cases since, hasn't had to be used in misuse of private information cases because they invariably involve confidential or private information about sexual relations and that sort of thing. But it's to do with the impact of not having an injunction. We'll look at this later. The impact of not having an injunction. He called it an invasion of privacy tort, and that I think is where the argument would go if there wasn't the vehicle of the inherent jurisdiction. So in von Hanover, which is, as I say, at 4274, paragraph 57, in the first part of the paragraph, the Strasbourg court took the big step of emphasizing that there could be a positive obligation on the state to adopt measures to secure respect for private life, even in the sphere of relations of individuals between themselves. So, in other words, as here, an injunction to prevent a publisher from publishing material about an individual asserting the Article 8 right, that's become known as the horizontal application of the Convention, as between the Article 8 and Article 10 rights. The second part of paragraph 57 is important and often cited. Although it's a little elusive, the boundary between the state's positive and negative obligations under this provision does not lend itself to precise definition. The applicable principles are nonetheless similar in both contexts, regard must be had to the fair balance that has to be struck between the competing interests of the individual and of the community as a whole, and in both contexts the state enjoys a certain margin of appreciation. So there's a suggestion there that you can bring into play in the balancing, whether on just one side or both sides, community, societal interests, concerns, public interests, as well as the narrow interests of the claimant and the claimant of the Article 8 right and the speaker. At paragraph 58 in the first sentence, the court recognises the need to balance Article 8 against any affected Article 10 rights of the press. The Strasbourg court took into account, this may be relevant for our consideration of the generic evidence point, if you look at 4267, a resolution of the Parliamentary Assembly of the Council of Europe following the death of Her Royal Highness Princess Diana. And you'll see at paragraph 14, 5 on page 4268, that what the Parliamentary Assembly had said was that the practice, perhaps unsurprisingly, the practice of the paparazzi and the press chasing private individuals to get photographs of them and so on and so forth was deprecated and should be prohibited by member states. If we then jump forward to page, first of all, 4274, where we get the reasoning of the Strasbourg court on the facts of the case. In other words, should the German courts have intervened to injunct? Was there a positive obligation? you can see at 59 that the court made a point of taking into account these societal considerations about the practices of the press. At the end of 59, it says, furthermore, photos appearing in the tabloid press are often taken in a climate of continual harassment that induces in the persons concerned a very strong sense of intrusion into their private life or even persecution. And again at 4276, paragraph 59. 68, I'm sorry, 4276, 68. Even more strikingly, the court finds another point to be of importance, even though strictly speaking the present application concerns only the publication of the photos and articles by various German magazines. The context in which these photos were taken, without the applicant's knowledge or consent, and the harassment endured by many public figures in their daily lives cannot be fully disregarded. So the court is going beyond the facts of this case to look at a societal issue which had been thrown up into stark relief by the death of Her Royal Highness Princess Diana. I should say von Hanover was cited in this, but not referred to in the judgment, perhaps unsurprisingly, as the Campbell case in this jurisdiction had kind of predicted what was about to happen in Strasbourg a few months before. The INRI BBC case is at page 2031. In this case, the Appellate Committee had made a reporting restrictions order in October 2020, preventing identification of a defendant acquitted of rape at the Crown Court, again at the Central Criminal Court, as the subject of an Attorney General's reference case that had come up on appeal from the Court of Appeal to the House of Lords. The order had been made in 2020, the anonymisation order, had been made by the Appellate Committee under the Criminal Appeal Reference of Points of Law Rules 1973. So purportedly a statutory power had been exercised in the Appellate Committee to make the reporting restrictions order. 10 years later, the BBC sought the discharge of the order in order to name the defendant in a documentary as the acquitted defendant in the Attorney General's reference case, identifying the case as one that should be reopened under the 2003 Criminal Justice Act. The issue in the Crown Court case was about not taking into account certain DNA evidence that the prosecution wanted to adduce. The committee considered that it probably shouldn't have made the injunction under the 1973 rules at the time it heard the Attorney General's reference. We don't really need to trouble ourselves with this, except on one point. It reached that view on the basis there was probably no power under the 1973 rules to make a reporting restriction order, to make an anonymisation order, as opposed to keeping the defendant's name out of the reference proceedings, so anonymising the defendant on the papers and not referring to the name in court. The Appellate Committee also took the view broadly that if it did have the power, it shouldn't have made such an order on the facts anyway, because the defendant, as I explained to my Lord Reed earlier on, had been identified in the original criminal trial at the Crown Court by name, and he'd been reported as the defendant, charged with rape and burglary. So he was easily jigsaw identifiable when the reference case was reported, because the facts were all the same. Notwithstanding this, the House of Lords considered that it had to decide whether it should keep the reporting restriction order in place, as I say, 10 years later, and faced with the BBC's application. The advocate to the court, Lord Pannick, argued that it should stay in place to protect the defendant, subject to the reference, to protect the defendant's Article 8 rights, relying on the obligation of the court as a public authority under Section 6 of the Human Rights Act to act compatibly with this convention rights. 3 members of the court gave substantial judgments Lords Hope, Brown and Neuberger, but they were all effectively in accord, and all of the members of the committee agreed with Lord Brown. And at page 2058, we get paragraph 54 of Lord Brown's judgment, which is a paragraph that my lords will have read in the judgments below. It appears in both of them. And Lord Brown was in effect saying that the dispute about jurisdiction to make the order 10 years before was irrelevant now, because under the Human Rights Act, Section 6 required the House of Lords as a public authority to act compatibly with the defendant's Article 8 rights. And if doing the res balancing exercise, an order was required, his Article 8 rights had to be protected. And then at page 2059 through to 60, you will see that he also considered at the end of paragraph 57, and this really is Lord Sales's point, that the Appellate Committee had the same general power to make injunctions as the High Court under Section 37 of the Supreme Court Act 1981, as it then was. I think I tried to persuade the House of Lords it didn't have that power, but not with much success. So it had the inherent power, comparable to Section 37, to make injunctions, including injunctions against the world, and that this, combined with its obligation under Section 6.1, gave it the power and the means to continue the reporting restriction order preventing identification of the defendant as the subject of the reference case. But on the facts, the balance fell in favour of the BBC. Lord Brown didn't refer to the positive obligation under Article 8 as per von Hanover, but of course, remember, this is a domestic decision of a domestic court. The court is not adopting a new measure to ensure respect for Article 8 rights. In fact, on the facts, it's much closer to the facts before the President in these cases, because the court was being asked, well, should we leave a measure in place? Should we leave an injunction in place to ensure respect for the Article 8 rights rather than lift it and expose those protected to the consequences? The third case in the trilogy is the Guardian News media case, which is at 3015. So just to pick up Lord Reed's point, you can see on that case, the information was in fact in the public domain from the Crown Court trial, the identity of the defendant. It hadn't been restrained in the Crown Court trial. It remained in newspaper archives. He was jigsaw identifiable when the reference case was reported. And the issue was, should he be protected against the risks involved in that? So it wasn't a straightforward open justice court reporting case. His Article 8 rights were, as it were, out there historically, and that's what was being protected. In the Guardian News and Media case, also very, very well known, in particular for the leading judgment given by Lord Roger, this court recognised, in a way that Lord Brown didn't in the BBC case, that the positive obligation under Article 8 may require the High Court to make a reporting restrictions order. And also, on the facts of that case, to prevent reporting of the identity of a party to the proceedings before it. And also it recognised on the Strasbourg authorities that a person's reputation may need protection as part of the Article 8 rights in play. The applicants were 5 claimants in judicial review proceedings who were challenging their designation by the government as being suspected of facilitating terrorism, attracting sanctions, in the form of freezing orders. And you can see, if you look at the end of the head note at 316, I think most conveniently, 3016, right at the end of the head note, you can see what their respective positions were. So the first two, A and K, their whereabouts were by now unknown. They'd left the community in which they resided. So their Article 8 rights were weaker. They were less likely to be identifiable in the community if the order wasn't made. G and H, or HAY, had already been publicly identified by the Bank of England as suspects and the subjects of freezing orders. So obviously their Article 8 rights were weak. But the fifth claimant, M, was still in the community in East London where they all lived, and had not been identified by the Bank of England as subject to a freezing order. So regarding the position of A and K, we need to look at paragraph 17, which is at page 3030. In particular, Lord Rogers' comment, as the Court of Appeal referred to this paragraph on the compelling evidence point. And you can read what Lord Rogers says, but he made the obvious point that they, having left the community in which they resided and their whereabouts being unknown, they didn't have terribly strong argument. They didn't have a compelling argument for protecting them. And as you know, we say that was the court simply commenting on the evidence in their cases, rather than prescribing any sort of rule or principle to be applied in the balancing exercise. At paragraph 29, 3033, again, your Lordships will have read this paragraph in the judgments below. Referring to M's case, the court recognises that where a reporting restriction order for anonymisation is made to protect a person involved in proceedings before a court, as distinct from simply ciphering the person or not referring to their name in the open court proceedings and discussion. This is done now in our jurisdiction because of the von Hanover positive obligation to protect them against the impact of being identified in connection with the court case, if that sort of measure is required to protect their privacy rights. And obviously it's a measure that goes considerably further than just ciphering them and not referring to them by name in open court. Because very often in these cases the press will know the identity of the person and will be able to report it, but they can't because they've been injuncted. And at 30, Lord Roger acknowledged that the power to make this sort of injunction had been established in RIES and the BBC. At 3035, paragraphs 37 to 42, Lord Roger reviewed the more recent Strasbourg authorities showing that protection of reputation is a right which can in principle fall within Article 8. That where the attack on reputation from a publication, but that if an attack on reputation occurred from a publication, but it didn't so seriously interfere with the person's private life as to undermine their personal integrity, this strand of the Article 8 right would not be in play. And that had been a contentious issue under Article 8 for a while. Many argued that Article 8 had never been intended to protect reputation, but these developments in Strasbourg, conditionally, as it were, brought in the possibility that reputation may be something that you could protect under Article 8. And the court goes on to refer in this paragraph, at the end of this section, that M's right to protect reputation under Article 8 was in play. And then at 61 and 62, 3041, regarding M's application on the facts for a privacy injunction for a reporting restriction order, the main argument of M in favour of an order is summarised and is maybe relevant to our case here. This is that M, the person asserting the Article 8 right not to be identified, in context would never get a trial in which he could challenge the substance of the allegation being made against him publicly if his name is published in conjunction with that allegation. That is the involvement in terrorism allegation. Lord Roger acknowledged that that was a valid point in his favour and perhaps the best point in his favour. We would say, tentatively, the situation of the clinicians in this situation is similar. If the injunctions are lifted, there will not be any hearing in the family division in which they can challenge or rebut any attacks on them that appear in the mainstream or social media. The order was discharged in M's case, however, essentially because of, rather like Re-S, the importance of the right to report court cases fully, identifying the parties to give the court report, that colour that comes with naming the parties in the case. We also need to look at paragraph 74 at page 3044, as it's a passage also referred to by the Court of Appeal, where Lord Roger discussed the evidence in M's case, having decided that the injunction would be lifted in his case. And again, we say that's really simply a comment on the evidence in his case. Again, it's not identifying any principle or rule, but evidence of harm has to be compelling for the balance to fall in favour of Article 8. And if I could just, before we leave, it comes in later, draw your attention to paragraph 75. There's a sentence that's oft quoted in these cases since, that the publication of M's identity in this context of the court reporting would make, quote, a material contribution to a debate of general interest. Central reason why the injunction was lifted, that there was some materiality to M being identified as a party in the proceedings. Finally, it's not mentioned in our case, but it's mentioned in our case, but not in the Court of Appeal judgment. There was a decision of this court in A versus BBC, which is at 1779, which was again a court reporting.
Sorry, I missed the page number.
1779, Lord. It was again a court reporting case. My Lord Reid may recall, and Lord Hodge may recall this case. It's a Scottish case. The media appealed to this court where a deportation order of a convicted sex offender who was seeking judicial review of the deportation order, alleging that if deported, his Article 2 and Article 3 rights would be infringed. The outer and inner houses of the Court of Session had preserved his anonymity in the judicial review proceedings. And in effect, the thinking was, we would subvert the deportation decision by creating more recent publicity about him as a sex offender if he was identified as the claimant in the judicial review proceedings, because it would report his case and his offence. The order in issue in that case was a direction under Section 11 of the Contempt of Court Act 1981, and that was open to the court because his name had been withheld in the judicial review proceedings. The other members of this court agreed with the judgment of Lord Reid, and this considered, amongst other things, there was a fairly comprehensive review of open justice, particularly in the Scottish courts. This considered, amongst other things, the way in which convention rights may be in play when the courts are asked to restrict reporting of open court proceedings. And so the two relevant paragraphs are at 1798 and paragraphs 46 and 48, where the court recognises that publicity about court proceedings, court reporting, could impact on the Article 8 rights of persons other than the parties to the proceedings, or indeed other than witnesses. And this can obviously happen in different ways. The name can come into the court proceedings. That's one way it can happen without the person being a party or a witness. So that the Article 8 rights of such persons may need to be balanced against the Article 10 court reporting rights in play. But we accept that those observations of my Lord and of this court were not directly in a case of this sort, where the court was grappling with somebody who wasn't a party in the proceedings. But we would respectfully suggest that they must be correct, and it must be correct to say you can, following von Hanover and the Guardian case, have cases where the Article 8 rights of non-parties and non-witnesses on the facts are engaged and might be seriously damaged if they were referred to in reporting or court reporting. So I promised to refer to the Wolverhampton City Council case, which is in volume 4 at tab 93, page 4378. It's a long judgment, but it seemed to us that these points were relevant. The judgment was given in November last year, so the court will broadly remember the fact it was considering the granting of injunctions against persons unknown, which would bind travellers coming to an unlawful encampment in future, in other words, newcomers, if they arrived and were considering staying at the site. It was a joint judgment of my Lords, Lord Reid, Lord Briggs, along with Lord Kitchen, with the other members of the court agreeing. And it reviewed, in a review of injunction law, amongst other things, the jurisdiction to grant injunctions, number one, injunctions against non-parties, number two, and importantly for our case, injunctions in the absence of a cause of action, a domestic cause of action. So regarding the first, jurisdiction to grant injunctions, we note and refer to at paragraphs 19 and 20, page 4389, the recognition by this court that the principles and practice governing the exercise of the power to grant injunctions in the High Court, now under Section 37, had necessarily evolved over time, and that in recent years new types of injunctions had emerged in response to the emergence of particular problems. The court also emphasised 19, 20 and 21, it seems to us, that the exercise of the jurisdiction must be principled, but the criterion is injustice, to be viewed in the light of temporary conditions and standards, not those, as Lord Nichols put it in the Mercedes-Benz case, not those of yesteryear. And we would say these observations are relevant here, given a number of factors. Three, really. First, very importantly, withdrawal of treatment issues arise in more and more paediatric cases because of advances in medicine and science, which may allow very sick children to be kept alive longer. This is a point made in the interventions by the health service interveners and the professional interveners. And in particular, if I could give you a reference, page 237, paragraph 9, in the intervention of the Royal College of Paediatrics and Child Health and the Paediatric Critical Care Society. So that's the first point. This is a changing situation in terms of science and medicine. Secondly, alongside this, the controversy they seem to engender seems to have become more and more acute. And thirdly, and perhaps most importantly, there is the exponential increase in unregulated citizen publishing on the World Wide Web in recent years, and that's well known. These combine to create the concerns in the Trust's evidence before the President. It's a particularly acute point in time from that point of view. Regarding injunctions against non-parties, at paragraphs 32 and 33 in Wolverhampton, page 4393, the court recognises a particular category of these, injunctions to protect human rights, following the Venables case in 2000. I don't want to go to that. We've got it in the bundle at 3388. And that was the case in which the then President of the Family Division, Dame Elizabeth Butler Schloss, made an injunction against the World preventing publication of the new identities of Thompson and Venables in anticipation of their reintegration into the community as adults. Although in practice, if one reads the report, the newspapers that wanted to publish the information, some of them, were before the High Court opposing the injunction. But it was rightly recognised by Dame Elizabeth that an injunction simply against them would have been valueless and unfair. To have the protective effect, it would need to go much broader than that and be an injunction against the world. And this was the first such case, human rights injunction protection, of human rights injunction protection, and was before the three appellate cases that we've just looked at. So we're jumping back right to the beginning of the Human Rights Act era here. There is a listing at paragraph 110, page 4413, of other cases in that line, the Venables line of authorities. It's a helpful listing. They are mostly cases of convicted defendants and the protection of their identity under Article 8 later on. Other well-known cases being the Mary Bell case and the Maxine Carr case, applying similar reasoning. But we rely on the recognition in that paragraph, very straightforward recognition in that paragraph at 110, that in these cases the court was driven, this is between G and H, was driven in each case to make the order by a perception that the risk to the claimant's convention's rights placed it under a positive duty to act. And that's precisely what we say the President recognised in his judgment in this case. As far as the third topic is concerned, injunctions in the absence of a cause of action, as we'll come on to discuss, and as the court may have seen from the judgments below, the parents' argument on jurisdiction before the President included this argument that you couldn't have an injunction except in support of a recognised cause of action against persons enjoined. That line of argument obviously failed in front of the President. But if we go to 4395 in Wolverhampton, paragraph 43, the court considered this issue and recognised that there had been numerous examples of injunctions in the modern era since the Siskina case, including the human rights injunctions that we've just looked at, where it's not the case, where it was not the case that you would have an underlying common law cause of action. and said, so it is now well established, this is at the top of page 4396, now well established the grant of injunctive relief is not always conditional on the existence of a cause of action. And one of the best known examples of this is the internet blocking order, discussed at page 4397, paragraph 49, the Cartier International type injunction, where there is no cause of action against the internet service provider, who is simply which is simply the conduit for the infringing material. But it will inevitably be impractical for the rights holder, the intellectual property rights holder, to go against those selling infringing copies online through that platform. And that's now a well-established form of injunction without a cause of action. And there are, it seems to us, similarities. It's not a perfect comparison, so I wouldn't put it any higher, but there are similarities with the injunctions in this case.
It's important, isn't it, in this particular context, to distinguish between the absence of a cause of action against the defendant against whom you're seeking an injunction, and the absence of cause of action in the sense that you've nothing known to the law which you're complaining about, which, of course, doesn't apply in a Cartier type of case. They've got plenty to complain about in the interference of their intellectual property rights.
Yes. But there has to be something like that to cling on to, I think, is
Yes.
what you're saying. There has to be, yes, exactly. You can't just be in the ether. You have to have a juridical basis for the injunction. The question is, what will that be in the absence of a traditional cause of action? And I say the comparison is not perfect because there's an obvious injustice in the intellectual property cases.
Yeah.
But there is going to be infringement by somebody. You just can't get at the person who's infringing. So it's a bit like a moravian. It's a sort of collateral assistance to the claimant. But our point here is, as we've always pointed out, if there's no cause of action against a particular defendant, these injunctions protect the clinicians against potentially unlawful acts of malicious third parties publishing online, who will be unsuable. It would just be impractical or valueless for a nurse or a doctor at a hospital, even if they could de-anonymize them, get an order of the court identifying through the ISP who the malicious actor is, which is a terribly tortuous process in the High Court. You don't have to fund it, you'd have to find your cause of action. Various causes of action are mentioned on the other side's case. Some were discussed in the Court of Appeal. There's a familiar list: harassment, privacy, data protection. But they're all out of reach for clinicians such as this in this situation. It's just not realistic, I think, is what we're saying. If you look at the submissions of the FSU and what I anticipate will be the submissions of Malone Friends, it's just not realistic to suggest they can pursue those remedies.
But that's quite an important jump from either Broad Idea or Cartier, isn't it? Because in those cases, there was no doubt that the claimants had a legal right which was being interfered with, albeit in Broad Idea they couldn't sue within the jurisdiction, and in Cartier they didn't want to sue the wrongdoers because they weren't essentially catchable or worth powder and shot. But you're, as it were, arguing by analogy, that also recognises, if you like, that where it's difficult for people who do have an infringement of their rights to complain about for funding or other access to justice or organisational reasons to sue, then that principle allows somebody else to sue on their behalf. That's what you seem to be saying when translating from there to the position of the hospital staff.
What I'm saying on this point is they could sue as individuals if the injunction was lifted and they were named and they were attacked. They could put the attack online into a pigeonhole, harassment, whatever the facts are, and they could try and sue the individual, but they can't do it.
And they could do it quiet time it if they were being threatened.
And they could do it quiet time if they were being threatened, but they still have to identify their defendant or go through the whole thing of suing persons unknown and so on and so forth. None of this is realistic for the clinicians.
Why can't they sue persons unknown?
Well, they can, but it's not easy, and it's not easy to enforce on the internet where anonymous actors who may not even be in this jurisdiction are publishing about you.
But if we're with you that the appropriate remedy is an injunction to prevent parents in this situation from identifying medical staff, that still leaves the issue which I think Lord Bruce was raising as to why the hospital is the appropriate claimant.
Well, yes, but there you see we've always relied on the principle that you see this articulated in the President's judgment. There is a vehicle, there is a case on the go, which was the one that they originally bought, and the issue has arisen in those proceedings about the discharge of the injunction, and that has to be resolved, as in the BBC case, by reference to the positive obligation under the Convention, Section 6, on the facts. The court is enjoined to do, the court has to do that as a public authority, and it becomes unimportant who the claimant was in the original proceedings. Proceedings are extant, and that issue is there for the court to resolve. So they're not really, it's not really comparable. They're not really suing on behalf of, not really bringing a claim on behalf of those clinicians. Their claim is the vehicle in which the court is having to consider the position of those clinicians, I think is the way that we would put it, and whether the positive obligation is engaged.
But the position would be different if there weren't those proceedings. Then you would have to have a claim by a named individual, not, well, anonymised claim by an individual.
Yes, and you would then,
And would a hospital be entitled to do that or not in such circumstances? Or would it have to be the clinicians or a representative proceeding on behalf of clinicians or what?
I think so, with a lead clinician, I think, with somebody suing on behalf of the group identifying themselves. But, I mean, obviously the same problem arises, which is these are doctors and nurses and clinicians at NHS hospitals caring for sick children. I mean, this is not a commercial case. It's not a situation where they can just group together and start to sue anonymous actors on the internet. It's almost impossible. Well, it is in practice impossible. So it's a very stark problem, because if this sort of remedy and relief and measure is not available, that's really it from their point of view.
I mean, we seem to be talking about two rather different things. One is whether any relief, even if a clinician came forward individually, could be effective to protect their rights after the event. And you seem to be saying not so. It's not practical to expect them to litigate at that stage, and it wouldn't be enforceable anyway. And then there seems to be a separate thing about who would be a proper party to make such a claim.
Yes.
And here we've got the trusts, and you seem to be saying, well, the trusts are an appropriate party to make a claim to protect the rights of others, which are the clinicians, because of the way the proceedings started.
Yes.
And could the clinicians personally have sought to intervene in the legal proceedings which have been brought by the trust if, for instance, it became clear that the trust was not going to ask the court to protect their interests, but they felt that their interest needed protection by the court?
Yes, I can't see any reason why not. I mean, if their Article 8 rights are engaged, and that's the basis of the jurisdiction, it seems unlikely the court would decline to hear them as interveners in that situation. Practically, the similar problem, well, not the same problems, but some problems would arise with that. But that would be possible. But again, it would. I'm going to come on to who's covered by the injunctions and how that works. But it would have to be. It couldn't be all of them. It would have to be a representative group of them, putting into play the Article 8 rights of the group as a whole. I mean, the problem here.
The trouble is that different levels of seniority of clinician might have a quite different strength or absence of strength of Article 8 rights.
Absolutely right.
I mean, the most senior might be equivalent to the captain of HMS Somerset. The much more junior might be, in that respect, in a much stronger position.
Absolutely. It's a point I'm going to come on to make, but I mean, I'm going to give this example. A clinical director at an NHS trust with a public-facing position
Yes.
is who happened to be a clinician in the case, is in a very different position from a trainee nurse
Yes, absolutely.
or midwife, in privacy law.
But it's slightly worrying that they all simply get put into a group. And then it's said, well, somewhere within the group there'll be people whose Article 8 rights are being interfered with, and therefore we can proceed, although we're the hospital and not even a member of the group, to get an injunction to protect them.
Well, I'm going to come on to this in due course because it loomed large in the litigation below. But letters were written by my instructing solicitors for both hospitals in the run-up to the discharge applications saying, will you identify the clinicians and the allegations you want to make against them so that we can properly formulate the injunction application and focus it. And the parents' solicitors declined to do that, and that evidence was never put in. And that clearly the President thought that was important. I'm going to discuss the pros and cons of that in due course, but that is another issue that looms here in these cases, because there is going to be a landscaping of Article 8 rights, but you need to know who you're protecting and what you're protecting them against, what allegation you're protecting them against, to weigh their Article 8 rights, and equally to weigh the Article 10 right to say those things.
As you know, there is a statutory rule that only a victim can rely on convention rights in legal proceedings.
Yes, but the question is, in domestic law, what does that?
Well, that's
what does that allow, and what does that
Section 7
preclude?
of the Human Rights Act.
Yes, but what does it allow, and what does it preclude in terms of domestic law procedure? Very often, I mean, we cited the Ashworth Hospital case, in the special hospital case in our case, which was an attempt to reveal a journalistic source on behalf of a special hospital, where the House of Lords looked at the hospital which was seeking to identify the source, and the problem it had protecting generally the confidentiality of medical records of its patients. And the House of Lords said, look, these are Article 8 rights, they're confidential medical records, they're very important. And it didn't seem to think there was any problem in the hospital praying in aid the Article 8 rights of those people in support of the application. Now, are they victims? Well, maybe they're not victims. Maybe that's the hospital referring to the rights of others. But where do you reach the point where you say that the victim has to be a party, and if the victim can't become a party because the other side won't identify them, should that defeat their Article 8 rights? But that's a domestic procedural question. I mean, they are, in the balancing exercise, they are victims. There are people whose Article 8 rights are being interfered with and infringed. There's no doubt about that. But the practicality of getting them before the court in this situation as individual claimants or as a group of claimants is considerable.
Yeah. Well, I'm just wondering how we fit these proceedings under the Human Rights Act.
Well, the way
I don't know.
The way they are fitted under the Human Rights Act is that the issue of whether the positive obligation to act arises and is before the court and can't be avoided under Section 6.1. And that's what the exercise that's being done there is a different exercise to that's being done in a classical vertical application case. It's a question of whether there's an obligation proactively to adopt a measure to protect those Article 8 rights visibly in play in the proceedings before the court.
So that is tying the right to raise this point into the particular proceedings.
In this instance, yes.
Yes, but the President's question if your answer is correct, would still be live in other proceedings. Let us say there weren't this sort of proceeding. What is the Human Rights Act peg that would allow a claimant to raise this point?
You mean the claimant, as per in this case, the NHS trust?
Yes.
No, I mean, I think I've accepted that there would have to be some form of claim brought as a group on behalf of the clinicians at the hospital with a lead clinician. It just wouldn't be practical for all of them to sue.
Against whom? Because obviously what you want to avoid is people on the internet, third parties, malicious third parties, manipulating the system and causing harassment, abuse, and upset. But that's not the parents. So who do you bring the case against?
Well, it would have to be against persons unknown, as per Wolverhampton, and those people would come.
Getting what order then, eventually? So you get an order to do restraining the parents as well as the persons unknown, or what? Well,
they would be caught by the order. Well, you could name them as defendants in the proceedings and in the order, but they would be caught. But anyone else acting in that way would be caught by the order, because they would be doing what is, in the Wolverhampton sense, doing what is prohibited under the order.
But the order, that sort of order will prohibit the malicious conduct that it's feared will be committed if nothing's done about it.
Yes.
But it's quite another thing to say, and therefore anybody who puts the relevant information into the public domain, which would permit those persons to use it in an unlawful way, is caught by the order. Well, the order can spell that out, of course.
Yes.
But the spelling out, if you like, provokes the question, well, why should someone who is merely putting it into the public domain with no threat to misuse the information nonetheless be restrained? I suppose the only parallel would be the Cartier parallel, but I'm not sure that a mere putter of information into the public domain is in the same position as an internet service provider of the Cartier type, where they are actually the platform on which the wrongdoers are committing their unlawful acts.
I was going to come on to this point because it's loomed in the proceedings in the past. Person A gets caught by the information going into the public, them putting the information in the public domain, and person B then acting unlawfully and maliciously on that information. There are authorities in this jurisdiction, Venables being an example, and some of the others in that line of authorities being an example, where the media are caught by an injunction preventing publication of a name or address in itself of no significance, on the basis that other people will react to it. That was exactly what happened in Venables.
Well, that's where the injunction prohibits the publication of the name. Yes.
Yes. I mean, there was no suggestion in Venables or Marybelle or any of those other cases that the media would somehow incite or improperly incite the malicious reaction of others. It was simply in context, the fact of that information being put into the public domain could have those consequences. And that was regarded as sufficiently important and worrying to catch everybody in a contravention of injunction from publishing the name.
But in the Venables type of case, the wrong is the mere identification of the person, isn't it, in the public consciousness? He is X. That dreadful man or person is actually called so-and-so, the new name that's been given.
Yes.
Whereas here the wrong is not so much the mere naming, but the conduct of certain types of people once they know where to aim their malicious observations.
No, I think in Venables and those other cases, there's another one we've got in the bundle involving Abu Qatada and the address at which he lived, where Mr. Justice Tugendhat injuncted a newspaper from publishing information about the address. It is others acting in consequence of that because of what's known about the person. What's different here is that the complaint is what's known about the person will be what's said by way of criticism by the parents about their conduct in conjunction with the end-of-life cases. They're not clinicians are not notorious criminals like Venables and Thompson or Mary Bell, but it is the conjunction of the two pieces of information in the hands of B, the actor, that is the problem you have to address. And that's where the interference with the Article 8 right comes, and that's where the positive obligation may arise.
So are you saying that in the Venables case, the injunction was not to protect the reputation of a particular individual, but was it aimed at protecting them from harassment? Are you going to show us that case?
Protect our lives.
Yes.
Against the, it was directed against, in a sense, the malicious actors, because if this information had got out, someone might have tried to kill them or whatever.
Yes, and the newspapers were saying, well, as A in my example rather than B, we want to be able to publish this information because it's in the public interest. It's newsworthy. These are criminals. They've come out after their period in prison.
So your point is that the jurisdiction existed to prevent someone creating a platform which malicious actors would then use.
Yes, exactly.
Well, not even a platform. It might just enable them to take steps themselves, not via the platform of the press, but they go around to their house and harm them.
Yes.
And we can come to Venables, but I think what Dame Elizabeth said is at one point is, I know not from where the danger will come, but my concern is that the danger will arise once their names and addresses are known, and how they're going to be put back into the community.
Well, it can be read across to other contexts. Police officers in Northern Ireland and their home addresses.
Very much so.
And you can think of other similar situations. So it's context-driven. It's a combination of factors rather than just purely an address or a name.
Yes.
It's an address or name. But could I pursue the point your representative proceedings? I wasn't quite certain where we ended up there, whether the parents were going to be parties to these proceedings or not parties, and despite that, still be affected by the orders of the court.
Well, I suppose that in the postulated case, it wouldn't have the history that we have in this case. You're saying you bring a freestanding claim.
Well, before there are end-of-life proceedings, you still have potentially the same problem.
Yes.
And what do you do about it?
But the basis of the claim, and we see this in all these cases, including Namique Riem, which I'm going to come on to, the judgment of Mrs. Justice Leven, is there has to be some basis for saying the parents are going to publicly criticise individual clinicians in a way that may have this consequence. This point is made in the interveners' interventions. In the vast majority of cases, very many cases, that isn't so. There aren't disagreements between the parents and the clinicians. There aren't these problems that might provide the basis for that sort of application. So you're assuming, first of all, that those facts exist and that you're coming before the court, rather like a queer timid injunction, with some evidence that the circumstances and what's happened thus far create this concern and this risk, this may happen. In those circumstances, you would be addressing in your evidence the speech of the parents and the conflict that's arisen with the parents up until now. And it would be very difficult to see how you couldn't join them if you wrote a pre-action letter to them and said, well, do you oppose this sort of relief? Do you want to assert your Article 10 rights to the point where you want to contest being caught by this sort of injunction? They say yes, they would be joined to the proceeding. It's difficult to see what the problem is with that.
Before you move on, Mr. Miller, can I just say, because it's an important point, and in case you want to come back to it, because you've got the rest of the day, but at the moment I don't find convincing your response to my question about Section 7. When you've got a chance to look at it, Section 7.1 enables convention rights to be relied on in two situations. One is where a person brings proceedings against a public authority, and the other is where a person relies on convention rights in any legal proceedings. I would have thought we're in the second of those situations at the moment. proceeding. But in either of those events, the person can only rely on the convention rights if he is or would be a victim of the unlawful act. So on the face of things, there is a rather technical, admittedly, but a rather technical difficulty here. And I'm not asking you to expand on your submissions on that at the moment, but if you want to come back to it later, then...
Yes. Well, my mind immediately goes back to INRI BBC, because if you look at the report closely in INRI BBC, you'll see that D didn't take any part in the proceedings and didn't assert his Article 8 rights. There was an advocate to the court in the teeth of the BBC's application, but there was no assertion of the Article 8 right. And what the court said, what the House of Lords said, is, well, that set of facts coming before the court engages the positive, in effect, engages the obligation under Section 6. So I don't know, they weren't troubled by that, the House of Lords wasn't troubled by that point in Re BBC, and I've always proceeded on the assumption that I will look at the Act and come back on that.
Yes, and you see, it's got much wider implications. It's a situation where one could have the state relying on convention rights as against the media, for example, which is quite an interesting scenario.
It depends what one defines as the state in that situation.
Well, in this case, it's hospital trusts, so they would count as the state, but it could equally well be the Ministry of Defence, for example, bringing proceedings to protect its employees who work on animal experiments at Porton Down.
Oh, yes, absolutely. And then in the line of authority, on a very limited line of authority in the High Court on harassment, and the difficulties getting group harassment cases going in relation to social media attacks. There are 3 or 4 cases that we go very far about prosecutors, about CPS prosecutors, where that has been a problem. They've faced that, and you know, one has to confront the fact that at the moment there isn't a readily formulated form of proceedings or substantive claim that exists in these cases. The courts, in the High Court in particular, is reaching around, if I can put it that way, to harassment and data protection and privacy and other possible routes to protect rights under Article 8 where they need to be protected, but without a simple route map in the law and in the procedure to enable them to do that. So there's a degree of creativity involved. That was really all I wanted to say on jurisdiction, and I will respond. I'll come back to that point if I may, but I'll respond to Malone Friend's submissions on jurisdiction. The President's judgment on balancing was the next thing we were going to consider in little detail, although we've touched on some of the points that I wanted to cover, because we say his reasoning and his determination was correct and indeed far-sighted and should be upheld. Before turning to his reasoning on the balancing exercise, I just wanted to address briefly some points about the evidence for the trusts and the parents' case before the President and what he said about it. And I confess we do feel some duty here to defend the reasoning of the President, because it was criticised in the Court of Appeal and doesn't seem to us fairly in some instances. The trust's evidence, the Court of Appeal considered that some of the trust's evidence summarised by the President at paragraphs 29 and 30 of his judgment, at page 326 to 7, was generic in the sense that it didn't relate to the facts of these cases or the circumstances of any individual. And at paragraph 125, at page 310, it doubted whether what it described as generic concerns of the sort expressed in this evidence could provide a justification for curtailing the right to free speech. And this has given rise to what we've called the generic evidence issue. Could the President take this evidence into account on the balancing as he did? So I'll address that in a moment. I just wanted to make these points at this stage on the facts of this case. First, the medical evidence in each case included a witness statement from the relevant medical director at the Trust with evidence about the facts of these cases, including the breakdown in relations between the parents and the hospital and their staff in each case, included evidence about the concerns of the paediatric medical and nursing staff at the hospitals about being publicly identified in connection with the case. So if we go to page 437 in the evidence of Mr. Andrew Welch, the medical director of the trust, the Newcastle Trust in the Abbasi case, at paragraph 59, page 437, witness statement, paragraph 59, he gave evidence that while Zainab was in the unit, Rashid Abbasi had repeatedly alleged staff were incompetent or wanted to harm Zainab. And then at paragraph 61 on page 438, he gave evidence about their concerns that they would be pilloried in the press and the social media if there was publication of their names in conjunction with Dr. Abbasi's opinions of them.
Is this a document put in on the discharge application, or do we have anywhere the actual original documents that were before the judges at first instance?
No, we don't.
Right.
This was canvassed to an extent in the Court of Appeal, and the procedure by which the original orders were made was looked at, and it's touched on in the Court of Appeal judgment, but there was no equivalent of this sort of evidence put before the court.
Before the lower courts, before Leaven J.
And McDonald J. No, it was really the fact of the end-of-life proceedings that had just been initiated. Initial directions had been given in the case, and the RO...
There was no affidavit evidence, no statement, and nothing put in?
No, I don't think so.
There were supportive witness statements from senior clinical staff about the need for an injunction in the best interest proceedings for both children.
Oh, I see. I'm told that there were references in the evidence in the best interest proceedings when they were commenced. Evidence was filed in support of the best interest proceedings.
Right.
And I think, as was quite common at that time, there was reference in the evidence of the hospitals generally to the need for this protection to be given by the court, but it wasn't dedicated evidence of this sort, and certainly at that stage wasn't targeted at this remedy in the way this evidence is. And then at 544 in the bundle, there was evidence about Rashid Abbasi's publicly stated opinion of the decision to withdraw treatment, which had appeared in a Mail article it's in the middle of that page, it said, of the clinician's decision to seek withdrawal of treatment, which was a very contentious decision and caused problems. He said, my daughter was given a death sentence half an hour before they arrived. That's the police. In the Haastrup case, the evidence was from Simon Broughton, the clinical director for child health, and this included evidence at page 463, paragraph 49 of that witness statement, that the King's treating clinicians were concerned that if the reporting restriction order was lifted, and I quote, there would be publication of accusations and allegations of deliberate mismanagement of Isaiah's care that have consistently been made by Mr. Haastrup. There was also evidence, if you go to 1459, in the media coverage of the case, in the Southwark News of the 10th of September 2017, of Mr. Haastrup saying of the clinicians, they want to end my son's life. And at 1478, an article in The Sun of the 28th of February 2008, that the judgment of the Court of Appeal was a judgment to kill him, that is Isaiah. If you go back to page 450, I should add that while on this evidence, because it's relevant later, that when Mr. Haastrup responded to Mr. Broughton's witness statement in a second witness statement in the discharge proceedings, he said that right at the end of page 450, that on the day that ventilation was withdrawn, some of the nurses present kept asking when he was going to die, as if they derived joy from it. The evidence in the Haastrup case also included evidence about the social media activity triggered by the end-of-life proceedings. And if you go to page 1520, which I hope is clearer online than elsewhere in the print version, there was a Facebook page called Steadfast Life Aid Life for Isaiah Haastrup, containing numerous third-party postings, which included references to, at 1520, legal murder, at 1521, medical murder, and at 1522, there were allegations of murder and corruption in connection with the case. It's true that the evidence on the applications to discharge the reporting restrictions didn't capture all of the social media comment against the decision-making in Isaiah's case, whether by the clinicians or the courts. But it does seem clear from these pages there'd been a certain quantity of that sort of comment at the time the case was going through the courts. The second point I wanted to make about the evidence was to use the terminology of the Court of Appeal. We would say that other points made in this witness evidence did relate to the facts of these cases and the circumstances of these clinicians, even though it wasn't about them specifically. Because the evidence, the point of the evidence was to identify the various ways in which clinicians in this context might be affected by public attacks on them. So if you look at the 10 points at paragraph 30 in the President's judgment, the 10 principal points that he extracted from the Trust's evidence at 327, you see at point 3 that there was evidence given based on experience in other cases of the vulnerability to attacks on social media. I'll come to some of that, mainly related to the Charlie Gardner, Alfie Evans cases and what happened in those cases. Roman 8, clinicians being unable to respond to attacks, which was an important point in the Trust's evidence, that faced with this situation, doctors and nurses are not allowed to, not able to respond publicly to the criticism of them. And also at Roman 9, concerns about what's known as doxing, which had happened in the Gardner Evans cases, which is people, once you've been identified, searching for and publishing identifying information and other private information about them on the internet, and that rolling on to, it could be physical addresses, it could be email addresses, it could be phone numbers, rolling on to a campaign of harassment. So all of that is relevant evidence, we say, and if the Court of Appeal was dismissing that as generic or not relevant, it was wrong to do so. The parents' cases, I just want to say, make 2 points about the parents' cases and what the President said about them. First, and I'm still defending the President's reliance on the broader aspects of this evidence, which was criticised by the Court of Appeal. Before the President, the parents didn't seek to challenge any of the evidence submitted by the trusts. That is paragraph 31 in the President's judgment at page 327. nor, perhaps more importantly, did they seek to argue that any of it couldn't be taken into account on the parallel analysis. But the point the Court of Appeal has taken against the President was not a point in play in the hearing before the President. Nobody said, as a matter of principle, you can't look at this category of generic evidence. It was simply not an issue for the President. We accept that at paragraph 48 in the President's judgment, page 332, a submission is recorded on behalf of the Abbasids that if the Trust's evidence was taken into account, their convention rights under Article 6 would be breached because there hadn't been a fact-finding procedure. But this was rightly rejected by the President because they'd been offered at the directions hearing, but declined the opportunity for any fact-finding in relation to their discharge applications. The parents' case, the second point I just wanted to make about the parents' case on the balancing exercise, it was quite straightforward, really, in a way. It was essentially that, one, the issues they wanted to speak about in general terms were of high public interest, so that the Article 10 rights were strong ones. Secondly, it was said the case for the clinicians under Article 8 was effectively precluded because the claim to continue the injunctions was a class claim of the sort described by Sir James Mumby in the 2010 family law case of A versus Ward. And you can see these two strands of their case being summarized by the President at paragraphs 46 and 47 in his judgment at page 331. Where he summarizes the Abbasi's case if they lose on jurisdiction. If you look at paragraph 50, you'll see that learned friend then on behalf of Mr. Haastrup adopted Mr. Locke's submissions. So in effect, the parents were making common cause on these 2 points. And thirdly, the parents took a point that it was not permissible. This is the point Lord Briggs and I were discussing. It wasn't permissible to restrain the parents' speech on the basis that others might attack them unlawfully or abusively if the injunctions were lifted. I'll come to the first point about the Article 10 rights when we look at the parts of the President's judgment that deal with the balancing. But the second point in the parents' case, what I call the Ward point, the class claim point, assumed considerable significance before the President and was also in play before the Court of Appeal. Ward is at page 1807, and Sir James was considering an application by an NHS trust in a family case on behalf of clinicians who had treated a boy with injuries, small boy with injuries, that the local authority, Cambridge County Council, had suggested in child protection proceedings were caused by the parents, and they'd suggested that unsuccessfully. They wanted an injunction against the world anonymizing them as a group of clinicians. And if you look at page 1857, the preceding paragraph, you can see that Sir James was directing himself that he had to do the balancing exercise in this case. He had to balance the Article 8 rights of the clinicians.
So which paragraph?
It starts at 179 on page 1857. It's quite a long judgment because there are other issues involved. And the key paragraphs that get referred to below are 180 and 181. But the point I'm making at the moment is he was accepting that this was a balancing case, that the Article 8 rights of the clinicians were engaged, and that he needed to balance. I think really I'm trying to get to what the reasoning was at 180 and 181. So he says that the clinicians, like the other claimants, need to be able to demonstrate the balancing exercise tips in their favour. So he is doing the balancing exercise. And then you can see what he meant by a class claim if you look at the end of 181 over the page, 1858.
And can I ask, how were the clinicians before the court in these proceedings? Had they made their own application for an anonymity order?
Yes, represented by Mr. Locke, yes. They argued a case as a group. I think that's correct. And the President heard them on that basis.
So it wasn't an application by the Trust?
No.
It wasn't?
No. No, they were applicants. There were applicants for injunctions in the proceedings, represented by their own counsel. So they were heard as a group, as indeed were the social workers in that case. And he said that the class claim couldn't succeed. You can get this at the end of 181. Because what they were really saying was that any professional, this is the way he puts it, any professional who falls into a certain class, and in the case of both the social workers and the treating clinicians, the membership of that class is very large indeed, is for that reason, and truth be told, for that reason alone, entitled in current circumstances to have their identity protected. So his objection was that they weren't really putting forward any evidence beyond the fact that they were the treating clinicians in that case. Seems to us it was solely the fact that they were the treating clinicians. So we don't accept that our cases can be categorized in this way because there was the evidence that I've just discussed. And as I've already said, and I'll explain in a moment, we tried to avoid being open to a criticism of lack of evidence about what was at stake for the individual clinicians by ensuring that the clinicians to be named and criticised were identified in the evidence from the parents. But that never happened. So we get the President's response to this part of the parents' case in two passages in his judgment.
Well, why couldn't they just have put in their own statements themselves? Say that I anticipate that there's a degree of upset between myself and the parents, and I'm concerned. Why do they have to be reactive rather than proactive?
Well, I'll come on to this in due course, but it would be an incomplete way of dealing with their Article 8 rights, and it would be an incomplete way of dealing with the Article 10 rights in play, not to be able to address what the substance of the criticism was and what the impact of that on them was, and whether it was true or not. That those are fundamental issues in relation to weighing the Article 8 and the Article 10 rights. You have to do it with a degree of specificity. So yes, they could have put in witness statements saying, look, we had this conflict with the parents. We think they may target certain comments at us, but we don't really know what they are, and we're concerned about it. But in effect, that's what the medical directors said on their behalf. We were trying to go further than that and assist the court in addressing, in specific terms, the value of the Article 8 and Article 10 rights in issue. The President addressed this first by reference to the differing approach of Mrs. Justice Leven and the Court of Appeal in a more recent end-of-life case, Re-M, in which a reporting restriction order, which we would suggest Sir James might have categorised as a class claim, anonymising the treating clinicians, was made. And you'll see that dealt with in the President's judgment at paragraphs 61 to 62.
Sorry, 61 and 62?
Yeah, which is pages 335 to 337.
Thank you.
And you may recall that he sets out at 61 the key parts of the reasoning of Mrs. Justice Leven in Riem, or as it was earlier known, the Manchester University Foundation case, in her judgment on the reporting restriction order. So he sets out paragraphs 11 to 16 of that judgment. And I don't propose to summarise those. I would commend them to the court, and the court will read the reasoning. It's the reasoning of a first instance judge in the family division faced with one of these applications.
This isn't a discharge application, as I understand it. This is an application made at the outset, presumably, of the proceedings.
No, this is a discharge.
Or was it a discharge? I don't know.
Kind of informal discharge. What had happened is she'd given a full judgment on the end of life proceedings, so they'd concluded. Okay. There had been an RRO. It's a separate judgment. You haven't got it in the bundle. There had been an RRO, and she gave a separate judgment dealing with the issues raised by the RRO and whether it should continue. And I think my learned friend was in the case for the parents, and there was a case advanced on behalf of the parents that the injunction should be discharged. It didn't have all the formality of our discharge application, but that's in effect what it was. The judgment is for your note, is at 2657. And I'll come later to a couple of parts of it, but we would simply make the points that the clinician's case for anonymity in that case was very similar to ours. In fact, it may be worth looking at it at 2660. In the report, if you go to paragraph 5, you can see the trust submitted a witness statement from Dr. G.
Sorry, could you give me a page number?
2660.
Thank you.
2660. Similar to ours, a doctor, Dr. G, supported the making of the injunction, refers to the fact that staff and herself have been psychologically affected by maintaining care for the child, etc. Well, you can read it. Same sort of concerns expressed by the lead doctor giving the evidence. And if you look at 17 in the judgment, you'll see that the order was a very wide one. This is 2665. The judge says, I do not accept Mr. Quintavale's argument that it's only appropriate to grant an RO if each and every person covered has been asked whether they wish for their Article 8 rights to be protected and evidence produced. In the present case, there are some 360 individuals set out in the annex to Dr. G's third witness statement. It would be wholly disproportionate and unworkable, she goes on to say. It's a reasonable assumption that members of staff treating the child would want their privacy protected. If for whatever reason they do not, then they're free to raise that with the trust. Her reasoning regarding Ward, which was considered by her in that case, this is the class claim complaint, is at 16. And again, I won't read it. In essence, she's saying that, and we would agree, that those that become involved in the end-of-life litigation because they treat the child are in a very different position from clinicians who choose to be expert witnesses. She says towards the end of the paragraph, I do not agree with the President that such clinicians simply have to accept what the internet and social media may throw at them.
Yes, I mean, the point's made, I think, in line 6, they come to court not out of any choice, but because they've been carrying out the treatment.
Yes. So she distanced herself from the analysis in Ward. The parents in Riem sought and were refused permission to appeal the ruling on the reporting restriction order on the basis that the judge had not followed the no class claims approach of Sir James, that you couldn't make this sort of claim in practice, that you would need more evidence. And the Court of Appeal endorsed the reasoning of Mrs. Justice Leven as per the passages in the Court of Appeal judgment in Riem. So there was an appeal on the end-of-life issues. There was also an appeal on the reporting restriction order. And the President sat in both, in the Court of Appeal in that appeal, which became Riem. And if you look at 337 in the judgment of the President, he set out at paragraph 62 what he had said in the Court of Appeal in Riem, refusing permission to appeal on the reporting restriction order. And we would say that the paragraph 102, and in particular the last few lines of it, are correct. What he said in dismissing the application for permission to appeal against the injunction was the need for openness and transparency in these difficult, important, and often controversial cases is critical, but can, in the judgment of the court, be more than adequately met through the court's judgments without the need for identifying those who've cared for M with devotion since September 2019.
Do you have the bundle reference for that judgment?
For
the Court of Appeal in Riem? Well, if you haven't, don't worry. It would just be helpful to have it for our note at some point.
It's in volume, I think it's volume 2. It's tab 39 in volume 2.
That's fine. I'm sure we'll find it. Thank you.
Yeah, which is at 3070, by which time it had become called in Riem Declaration of Death of a Child. And it deals with the refusal of permission on the withdrawal of treatment issues, but then at the end deals with the reporting restriction order.
So doesn't the quotation of paragraph 102 in effect mean that what you're entitled to say is limited to what's contained in the court's judgment? That's a filter on your freedom of expression.
I don't know enough about the facts of what the parents wanted to say, what the parent wanted to say in Riem, to be able to say what the significance of that.
But taking that as a general proposition, it would be quite a restriction on freedom of expression to say you can only talk about what's contained in the court's judgment.
Yes, but I'm only being slightly cautious because I'm not sure that what was intended to be said was as broad as the parents want to talk about in this case. I think, looking at Leven J's judgment on the reporting restrictions order, that the parents wanted to criticise certain aspects of decision-making in bringing the end-of-life proceedings to court. And I think that some of the clinicians were witnesses in that case. So it may have been the focus in that case was rather more on. But no, I would accept that as a sweeping proposition. Is that a convenient point?
Yes, thank you very much, Mr. Miller. We'll adjourn now and resume at 2 o'clock.